I'd like to give each of you the opportunity, if you'd like to just give us some key takeaways. And since David just spoke, we'll go with Amar. Amar, can you sum up about a minute or so some of the things you'd like the audience to most remember from your talk today?
Sure, yeah. And so I guess in summary, I wanted to reinforce or emphasize that, for ERISA DC claims, the damages framework is generally comparing what would have occurred, looking at but-for returns, and then comparing them to a world that actually happened. What is the actual plan asset? And there's various considerations there, just to reiterate. One is, well, what would the but-for returns or but-for assets look like? And there's various assumptions and considerations that go into that calculation. The second is that, the time period of damages is really a fact-specific, really both are fact-specific and data-specific questions, that there are data out there that the expert can rely upon in informing what the time period would be or what the alternative investment would be. So it's not simply taking what the best performing fund was and calculating damages off of that. It really needs to be rooted in the facts of the case and the allegations, and this whole concept of loss causation, tying the breach to the damages calculation and tying the facts. So those are all important considerations. And again, what those assumptions are that underpin the analysis will have a material impact on the result.
Thank you for that, Amar. And David Johansen, some key takeaways for the audience.
Okay, thanks, Sal. And I just want to say I've enjoyed speaking with Amar today and appreciate the opportunity, Amar. It's great. One takeaway I would share with is when you're faced with defending ERISA fiduciary litigation or ERISA litigation of any kind, it's important to have a great team to defend you. There's plenty of great attorneys throughout the country who can provide those services. Make sure that you learn their experience with similarly situated cases and that you feel like they have the experience to defend you. But then it's important to also have as part of your team an ERISA fiduciary defense expert, potentially, obviously a great damages expert like Amar works with typically. And then I think have those experts hire the correct people, like a person like Amar, to do the analysis to help you properly defend the case, because damages is where most cases are won and lost, obviously after the actual litigation occurs. From my side, I'll just add two other points just about the presentation I made. I think it's really important to put yourself in a position as an ERISA fiduciary that you have the correct kind of understanding of your responsibility in connection with being an ERISA fiduciary. Hire competent professionals to advise you as to how to document your role, because most of the way cases are won or lost as an ERISA fiduciary is what you do in terms of documenting the steps that you took to protect the ERISA plan and its participants while you served as an ERISA fiduciary. So all of this stuff that Amar went through in his presentation have great documentation of that, the analysis that you've done as an ERISA fiduciary to show that you've complied with your ERISA fiduciary responsibilities. Hire the right professionals to assist you. Hire individuals like Amar to help you do the analysis up front, so that down the road, when you do get challenged, if you get challenged, that you can document that you've done the right thing and acted in the best interest of plan participants and beneficiaries. And I would say that's probably my key takeaway is understand your role, understand what is a fiduciary action and what is not, and then hire the right professionals to assist you in fulfilling your responsibilities to the ERISA plan participants and beneficiaries.